Right, this is LAWS 12066 Land Law, and this is the lecture for Topic 7, Leases Part 2. So in the previous lecture, we looked at Introduction to Leases. We looked at how a lease can be created in law and in equity, and we looked at different types of leases that are understood by the general law framework. And we then importantly looked at lease covenants, and that they can be sourced either implied by general law or the relevant provisions of the Property Law Act and to some extent the Land Title Act with regard to leases, or, and importantly, by express inclusion by the parties into the lease itself. What we're looking at in the second lecture is basically three broad themes. We're looking at assignment of leases, and in that regard we're asking, well, what is the situation in terms of assigning or transferring the leasehold interest by the lessee, and what is the situation in terms of assigning the interest that the lessor has or the owner of the land has, and we refer to that as a reversionary interest, because for the duration of the lease, the lessee has the leasehold interest. What is left to the owner is referred to as the reversionary interest. And, you know, the practical situations there is that with regard to a lessee, as we've said, these general law leases are today, we're talking about mostly commercial situations, so that a business might be transferred to another party, and with it, the lease entitlements to this new party taking over the business to operate and run their business. So that's issues around the transfer or the assignment of the interest the lessee has, the leasehold interest. Of course, the owner of the premises, the lessor, can sell the land, can sell the premises. That is what we mean by transferring or assigning the reversionary interest. That's when the lessor is basically selling the land, or may well be gifting the land. That's sometimes possible, but in commercial situations, it's mostly about them selling the premises and during the currency of a lease. And that, even though that doesn't happen usually in residential situations, because incoming purchasers want to buy with what's called vacant possession, in a commercial situation, of course, the whole rationale behind the commercial premises is that they are being leased to generate income, so that it's not uncommon for, when commercial premises land is sold, that there's a lease on foot. So there's those situations. We then turn importantly to look at remedies. What happens, what can the parties get access to when something goes wrong, or when terms or covenants in the lease haven't been fulfilled or abided by. And in that context, we need to understand that a lease has contractual characteristics. So it is a landlord-tenant property law relationship, but it sort of has contractual features to it. And so when we come to remedies, we'll see that there are contract-like remedies that are also possible, as well as property law type remedies. And then lastly, we just touch on briefly some examples, or highlighting those types of leases today that are governed by specific legislation. And the two main ones are the retail shop leases situation under the Retail Shop Leases Act in Queensland, which was amended a couple of years ago, 2016, and I've given you on the Moodle website versions of that and the amendments. And then there's also the legislation specifically dealing with residential tenancies, which is the residential tenancy and rooming accommodation legislation in Queensland. We just basically touch on those. We haven't got the opportunity or the space to go into them in detail, but just bring them to your attention. From a practice point of view, in terms of working and being a lawyer in this field of property law, you will encounter this framework of general law with regard to commercial leases most typically. You also may be asked to advise in relation to a retail shop lease, either for a lessee or a lessor. In the area of residential tenancies, that is a field that's been very much, in a way, taken away from lawyers, or lawyers have been removed from the process. The anticipation is that the parties will basically deal with themselves with standard forms, standard agreements, and for, to facilitate the process and not to bog it down with lawyers wanting attention to detail and all this sort of thing. However, that having said, in the area of residential tenancy, of course, landlords are very often represented by agents, particularly in disputes that go to tribunals and so on. But again, we just mention that because in practice, it's not really the case that lawyers have a lot of dealings with the residential tenancy legislation, except if it's in the area possibly of social housing. We'll touch on that in the next topic just a little bit. All right, so without further ado, just going to screen share firstly the slides. So we are looking at firstly assignment, and as I said to you, we're distinguishing here between the parties that are assigning. We're talking about the lessee, we're talking about the lessor, and we're also concerned about how can enforcement action be taken following assignment, because the parties and these new parties, these new third parties that have come in a different relationship to the original parties, and challenges around the contractual relationship. This gives rise to thinking about what's been referred to as the doctrine of privity of contract. You can see there that the first dot point, and then in the third dot point, this idea of privity of estate. And what does this notion of privity of estate enable? Basically, this is a way of, in some form, being able to take action against the incoming party, the assignee, when there isn't any original relationship. Okay, and that sort of goes back to, in the first instance, with regard to leases or leasehold interests, the privity of contract idea that in new parties can't actually be a party to this original contractual relationship, insofar as we're talking about that being a way of understanding this relationship. It also is property law based. This is where we get to this tension between contractual understanding or contractual features and property law understanding in terms of the lessor-lessee or landlord and tenant relationship. Right. So in terms of assignment of a lease, we start by just distinguishing these ideas of privity of contract and privity of estate. And you can see there, if you have a look at the notes, that due to the doctrine of privity of contract, in terms of an assignment of a lease, the doctrine of privity of contract operates so as to maintain the contract, that is the lease between the assignor and the lessor. Okay, the assignor being the original lessee, and the lessor, of course, being the owner or the landlord. Given this operation of the doctrine of privity of contract, there is in effect no contract between the lessor and the assignee, that is the new incoming third party that's taking the lease. The lessor has the ability under the lease to take enforcement action against the assignor for any of the assignee's breaches. But one of the challenges here, of course, is that the assignor, the original lessee, maybe out of the situation, and being able to do that might be challenging. So a way of dealing with this is with regard to what's referred to as the doctrine of privity of estate. And basically what this says is that this doctrine of privity of estate is between the lessor and the assignee, and will operate so that any covenants that touch and concern the land will be enforceable as between assignee and lessor. Any covenants that touch and concern the land. The question of whether a lease covenant touches and concerns the land will depend upon the nature of the covenant to be enforced. Now, you can see there reference to the Sandhurst case, which is a relatively recent Queensland decision. And you can have a look at the Sandhurst case in your casebook with regard to this particular issue. The other point to note here is that this idea of touching and concerning takes us to provisions of the Property Law Act. So I'll just stop screen sharing the slides for a moment and show you legislation. So we can see there Part 8 deals with leases and tenancies, and we looked in the last lecture at those provisions to some degree that dealing with creation and types of leases and so on. Division 2 deals with surrenders, assignments and waiver, and we're looking at section 117 and 118. 717 looks at the rent and the benefit of the lessee's covenants to run with the reversion, and the obligation of the lessor's covenants to run with the reversion. Now, these ideas were about running with the reversion. That's actually when the lessor is assigning their interest. Property may be sold. So the entitlements with regard to the rent and the benefit of the lessee's covenants going with the reversion of the interest to the assignee of that reversionary interest, the new owner of the property, and also the obligations of the lessor's covenants to run with the reversion. Now, the challenge here is that there's been a body of case law that has interpreted what this idea of running to touch and concern the land and running with the reversion, and what does that mean? So just going to stop screen sharing that for a moment, and just want to show you again that this is an area that's been affected by, or commented upon, better way to put it, by the Property Law Review 2018. Now, I mentioned earlier in the first lecture that there's a big chunk of the report dealing with leases, and certainly you don't need to look at all of that, but you can just be aware of it, but not required to work your way through it. But you can just note, for example, that there's a discussion of these critical sections 117 and 118. And what's interesting is, gives a bit of an overview, which is quite helpful, talks about the nature of the provisions, refers to relevant case law, up-to-date case law, which is very helpful. And then the other point is that it says there are some issues with the section. You can see there that this idea of touching concern, the rules regarding, this is on page 637 of the report, rules regarding whether or not covenants touch and concern the land have been described as arbitrary, quite illogical, for example, and there's reference there to a Victorian Court of Appeal decision in 2012 looking at these matters. And, for example, commentators note that the case law can give little comfort to a person seeking to give firm advice on the question of whether an assignee is bound by covenants in a lease, and further that serious issues must be raised about the maintenance of such a doctrine which defies any logical explanation and seems to be decided on a case-by-case basis. There's case law in your casebook that you can have a look at that highlights these dimensions of trying to establish whether a covenant touches and concerns the land. We can see a bit further down on page 638 of the report that lessees' covenants that have been held to touch and concern the land include, for example, the payment of rent, rate, taxes and charges, repair to buildings and fixtures, keeping the premises clean, insurance, monies in relation to improvement, and not to assign the lease without consent of the landlord. Right? Covenants, the lessor's covenants that have been held to touch and concern the land include supply of water, not to build on the adjoining land, maintain parking areas, to renew the lease if the tenant exercises an option to renew. Covenants that have been held to be personal. Now, this is the issue, okay? So we've seen this idea before that a bit earlier in the unit where we looked, for example, at the terms or the covenants in a mortgage. And we said that only those covenants that touch the estate of the land will actually receive indefeasibility and thus protection under the LTA. In this context, if a covenant is deemed to be personal between the parties, it will not run with the land, it will not touch and concern the land. So covenants that have been used on page 639 of the report, covenants that have been held to be personal and therefore do not run with the land include an option to purchase, an agreement for the lessor to purchase the lessee's fixtures, and payment of the money at the end of the lease, sometimes something referred to as an incentive payment sometimes as well. So there are various issues that are discussed here, and you can have a look at those just by way of reviewing these sections, and also gives a nice overview of what's going on in other jurisdictions. The recommendation, we come down to the recommendation of the review authors. Section 117 should be retained with modernised language and amended to remove inconsistencies and provide that all covenants run with the land unless expressed to be personal. So basically, to provide clarity, all covenants will actually run with the land following an assignment, except if it's specified that they are personal. Now remember, these are reform proposals. Doesn't constitute the law at the moment. So we've still got to come back to the framework of benchmarking against the legislative provisions and the case law in terms of determining whether or not the covenants apply to the assignee, whether they can be enforced against the assignee, and that comes down to the doctrine of privity of estate in terms of how that's been explained. But we also need to benchmark against these provisions with regard to this idea of touch and concern, and not everything will be, but some covenants have been held to touch and concern, but sometimes it can be equivocal, as we've seen, as you will see in the application of case law to scenarios and situations. Nothing in the law is actually cut and dry, okay? And that's something you should bear in mind all the time, okay? You have to reason through your analysis in looking at case law in application to a situation at hand. Nothing is cut and dried where you can say, oh yes, this is it, so therefore that's done and dusted, I've got the answer. No, it doesn't quite work like that. When we come to section 118, the obligation of the lessor's covenants to run the reversion, again, just the similar concerns have been raised, right, in the same way, right, and documenting as above. So what is the recommendation here? Similar to with regard to 117, that 118 should be amended to modernise the language. This is on page 647 of the report. And aid in interpretation of this section, the amended provision should remove the touch and concern requirement and stipulate that all covenants in leases run with the reversion unless expressed to be personal. So clarification, modernisation of language, and all covenants will run except if it is specified to be personal. But again, these are reform proposals. They don't constitute the law just at the moment. So just stop screen sharing that. Let's go back to the trusty slides. So you can have a look at the discussion with regard to assignment, with regard to the doctrine of privity of contract, privity of estate, and also this idea of touch and concern, right? Just come back a moment. In terms of what we're saying is required before we can enforce obligations against the incoming new parties, either in the context of a lessee or in the context of a lessor. The other point that we need to tease out is that in the context of assignment of a lease by a lessee, we need to distinguish the action or the conduct that gives rise to an assignment of the entirety of the lease as opposed to a sublease. So the assignment of the entirety of a lease is where the lessee is assigning all of what they are entitled to as lessee, their entire leasehold interest. And we've seen that that's characterisable in various ways, but essentially it's about having exclusive possession, certainty of duration, and quiet enjoyment of the property with other relevant covenants applied and dealt with. If a lessee is seeking to sublease, what they are in reality doing is they are actually taking a part of their leasehold interest, and they are transferring that or creating another lease interest with another tenant, so that the lessee, in effect, becomes a sublessor to a sublessee of the leased premises, which is a part of the area that's being leased. Okay, there might be, a little area that can be further divided, and essentially in a business, a commercial situation, this happens because the lessee is trying to generate some income, which may assist in them meeting their obligations and rent under the lease. But again, there will be qualifications quite typically in a lease with regard to subletting that will very typically require landlord approval or lessor approval before that can be undertaken. But in this context, we're distinguishing an assignment on the one hand from a sublease on the other. Of course, in the situation of reversion, you can't be transferring part of the ownership. You're either selling the land, gifting the land, or not. Okay, so most typically that's what is occurring. Right, so from there, we then look at the idea of remedies, and we have this first area that's referred to as the forfeiture of the lease by the landlord. So the forfeiture of the lease means that the lessee loses the lease and all interests and rights to possession of the demised premises that flow from the lease. Forfeiture is the most dramatic of the lessor's remedies. So it's forfeiting the lease back to the landlord, if you like. That's what it means. Because of the drastic nature of the remedy of forfeiture, the procedure by which a lessor can forfeit a lease is regulated by statute. And we have those statutory requirements that must be strictly complied with for the lessor to succeed. In our case, that takes us to provisions in the Property Law Act. And you can see there in the slide that there's reference to section 124, sections 123 to 128, forfeiture in relation to subleases, section 125, and also a remedy of self-help. And you will see that these are discussed for you in the casebook and also in the slides. Again, we'll just go back and have a look at the legislation on this. So again, we've got Division 3 dealing with relief against forfeiture. And you can see there, section 124, restriction on and relief against forfeiture. It's a fairly long section. 125, power of the court to protect under lessee that's a sublessee, on forfeiture of a superior lease. Imagine if the lessor is trying to forfeit the lease, that's going to have implications for any sublessee. Costs and expenses, relief against notice to effect decorative repairs, there's something specific there. 128, relief against loss of the lessee's option, so when an option is on foot. How is that dealt with when the lessor wants to forfeit the lease? And again, there'll be discussion of those particular provisions in the review report, which you can also have a look at. Now, so these are actions that can be taken by the landlord with regard to the forfeiting of the lease, that is the entitlements under the lease, in particular the rights of exclusive possession and quiet enjoyment and these sorts of things, right? We also then need to consider the fact that there are remedies for both landlord and tenant in contract because of these contractual features of a lease relationship, okay? This gives rise to the idea of what type of relief is possible under contract. As we know, according to the common law, the sort of remedy that contract normally provides for breach of a term is common law damages. So we come back to decisions that have been decided in contractual situations, Progressive Mailing House and Tabali, and Gumlin Property, which deal with the idea of the contractual relief that's possible and how that might be able to be accessed and what sort of contractual remedies will follow. And we can see that we can talk about action for damages for breach of covenants under the lease, for example. We can also seek action to stop or prevent covenant of the lease from being breached, and that could be either side, both either the landlord or the tenant, okay? And don't forget that in a commercial situation, the bargaining power between the lessor and the lessee is often more balanced than it is, for example, in a residential tenancy situation. But the other point here is that what are the parties actually seeking? Are they seeking financial compensation? Often what the landlord is looking for is to forfeit the lease and re-enter the premises so that the landlord can take back the premises and basically re-let them, okay? There's also the issue around potential repudiation and termination, these sort of contractual type remedies, okay? So we've got, as I'm just pointing out there, we've got this idea of repudiation relief against forfeiture, which is a relief that a court of equity was able to recognise as being too harsh. What was the basis upon this? And then we got into this debate around breach of essential and non-essential terms. This again takes you in this direction of, you might remember from your contract law studies, of what was the basis of basically being able to bring, to walk away from obligations under that relationship. And then other issues around, for example, plea of set-offs, and also how bonds work in the context of lease relationships where they are can be on foot. We also just need to be mindful that today, in that array of remedies that are possible, we have to also remember the statutory relief that's available under the competition and consumer legislation. And just be mindful of that. You can see that that's discussed in your casebook at 8.210 It's paragraph number 8.210, and just have a look at that in terms of the response by the ACL in terms of providing relief in this context. Right, so from there, we just finish up by creating an awareness. That's all we can do really in the context of this unit, of these areas that, as I mentioned at the outset, are governed by specific legislation. And we have retail tenancies legislation, and we have, retail shop leases legislation, and we have residential tenancies legislation. So we've got the Retail Shop Leases Act 1994. We've got that being amended in 2016. And then we've also got the Moreton Bay and Meek Pine decision in 2016, looking at some of this situation. So again, just have an awareness of that. This is legislation that specifically governs retail shop leases, but only those that fall within the definitional parameters of what a retail shop lease is under the Act. And just because you're in a retail shop situation doesn't mean that it's necessarily governed by this Act. It has to fall within the definitional parameters of a retail shop lease. And the legislation was essentially introduced in the context of large shopping centres and things of this nature to move away from the general law framework and provide a more streamlined approach to those type of lease arrangements. But it can be in smaller complexes as well. That's entirely true, but it must fall within the definitional parameters of what is a retail shop lease for the purposes of the governance under the Act. And then we have the situation of residential tenancies, the Residential Tenancy and Rooming Accommodation Act 2008, dealing with residential tenancies and also other types of accommodation situations that are not private residential tenancy arrangements or under agreement. So this Act extends to those. That's not the case in all jurisdictions. Sometimes those other types of interests are dealt with separately, but in Queensland they have been brought under the one Act. We don't, as I say, have the opportunity or the space, time to go into this in detail, but it's a specific regime for residential tenancies. It's streamlined, it's got standard forms and processes. Disputes are taken to a tribunal, the QCAT, not through a court. Parties represent themselves, but landlords most typically are represented by agents. But there's an emphasis on informality. There's an emphasis on parties doing things themselves. There's also an emphasis on plain language and simplicity up as far as that can go. And that's just have an awareness of that in terms of the regime that is relevant for residential tenancies. Right, so that brings us to the end of this lecture. And as I mentioned at the outset, we saw in the first lecture that we looked at the essential characteristics of a lease. We looked at the idea of what do we need to determine whether we have a lease or something that's not quite a lease. What are the rights and duties between the parties? We looked at the covenants under the leases and the various sources of that. And then we've looked here in this topic at assignment. Just stop screen sharing the phone. We looked at assignment and we've looked at remedies, very important. We've seen how remedies work both in terms of the property law features and the property law entitlements, but also significantly these contractual type remedies that are available too because of the contract-like nature of a lease relationship. And then lastly, we've just focused a little bit on highlighting the existence of particular regimes that are governed by specific legislation, and that's the retail shop leases relationship or the situation and residential tenancies. So there we are, folks. That's the second lecture on leases. It's a big topic. We're spending 2 weeks on that topic. Next topic we soldier on. So until then, bye for now.